Hello students, welcome to my channel and in this channel I'm giving you law tips. So like I said, this is the season of SO, that is specialist officers in banks, and I'm going to give you tips of how to clear the law officer interviews, that is specialist officer interviews, that is scheduled for March. And today we are going to see about the company law. So like I said, one of the important functions of you being a law officer is to evaluate the company for which your institution, that is bank, is going to lend. So today we'll see some of the important tips, how questions can be asked, and what are the sections that you have to remember in company's law. Before I start the class, let me tell you, I have more than 5 years of experience as a law officer, as advocate, working in banking matters. I have worked in UCO Bank. Currently, I'm a legal consultant in NABARD, and I have also given various legal opinions. I've also been an international trade finance lawyer for a company called Tredfin. So without any things, we'll straight away go to the class. And before going to the class, if you feel this video would be beneficial for any of your friends who's preparing for law business examination, do share it with them. And don't forget to subscribe and like this video. And if you have any comments regarding the teaching method, or if you have any doubts, don't feel free to put it in the comment section. I would individually answer each and everything. Like I said, the Companies Act is a voluminous act. It has a lot of sections, and whether you have to understand each and every section in depth is up to you. But I would say for interview, what you need to have is you need to have a tropical level of understanding of the company law. Now, when I say tropical level of the understanding, you should be able to differentiate between the types of company. This is an important aspect. Then the finances of a company and certain important things with regard to banking. Now, what is the most important thing we wanted to understand as a company? Why would someone recommend you to incorporate a company? That is one of the most important thing. The most important thing with regard to companies law is that it has a separate legal personality. It has a separate legal personality. That is the most important thing. So when I say it has a separate legal personality, it means that the company is separate from its members or any persons working here. So it has separate legal personality, which means the company itself can be sued or the company can sue others. And moreover, another important concept is the limited liability. That is uh, limited liability. So what exactly is limited liability? A limited liability is a concept which means the company's liability is limited. It can be limited either based on the shares, which is the usual form of company, and or either guarantee. Which means that, say for instance, if you are having a sole proprietorship, in sole proprietorship, in case the company becomes if your sole proprietorship becomes insolvent, then you as an individual is completely responsible. That is, your assets, your personal assets, personal belongings can be sold to fulfill the company's debts or to fulfill the company's creditors. Whereas as a company, because company is a separate legal entity, the assets of the company is different from your own personal assets. So the risk of your personal belongings getting wiped away in case of insolvency is very less in terms of company. So that is one of the concept of limited liability, and the liability is based on, of course, the memorandum of articles MOA or articles of association AOA. So it can be either limited by guarantee or shares. Now, whether this question will be asked in a law officer's interview, Evolution of company legislation, I don't think so. Anybody is going to ask you because you're not going to be a company secretary. But still, it is good. It is not going to harm you if you know this evolution. So there are four important stages. One is 1850, that is usually the Act for Regulation of Joint Stock Companies. Then 1913, which introduced the Companies Act with significant provisions. Then, of course, in 1956, which had a comprehensive structure and major changes. And now the Companies Act that we are following is again revamped in 2013. So this one was again revamped in 2013. Now, what is the meaning and nature of a company? Like I said, this we have already seen. It has a perpetual succession. That is, the company succeeds on its own for n number for like in it has a perpetual succession until unless it can be either liquidated or wound up as per the statute or laws. It keeps on going. It keeps on going, and it keeps on. The office keeps changing from one person to other, but the company will not go extinct unless it is going through a winding up process or liquidation. So limited liability, perpetual succession, easier capital raising, all these are in fact advantages, and the disadvantages are like of course if you have to have a company, then you would have a lot of complex compliance mechanisms, tax structures. You need specialized accountants, auditors to look after the uh, finances of the company. So of course really complicated in that sense. Now, how a question can be asked in these matters is like, say for instance, if you're a law officer, simply generally they'll ask a question like, tell me the advantage of a company. What is the company? How is a company different from sole proprietorship? And those things can be asked. And also questions like, what are the disadvantages of a company? All those things. Next, coming back to the comparison between a company and a partnership. So, what is a company and what is a partnership? Like I said, a partnership is usually governed by a partnership act, and the partnership itself will be governed by the partnership uh, agreement, the partnership agreement, or if certain issues are not covered in the agreement, then it will be based on the partnership act. But the major part is the liability is unlimited. And partnership, the liability is unlimited, which means in partnership, if there is an insolvency, the partner's personal property will be brought into the picture and it might be sold. That's the importance with regard to, how is it different from an LLP? How is a company different from an LLP? LLP is a limited liability partnership. So an LLP has a hybrid structure with limited liability, and the compliance requirements are lower in LLP. But the important thing is, usually LLPs are for law firms where lawyers cannot take up cannot take up employment, but however want to be part of an organization, but at the same time the organizational structure does not want to resemble like a company or like a sole proprietorship or a normal partnership. Then LLP would be the structure, and usually LLPs are for firms which gives you legal services or accounting services. So the companies have shareholders, where LLPs have partners.